Hello students, this is exercise number 24 of the Progressive Monthly Magazine, October 2021, on the speed of 100 words per minute. Start. The Learned Council then referred to the rationale for enacting Section 238A by referring to the Insolvency Committee report, which introduced the aforesaid section and strongly relied upon the fact that in all these cases, recovery proceedings were ongoing before the Debt Recovery Tribunal and or the appellate authority under the Recovery of Debts Due to Banks and Financial Institutions Act 1993, and that by not applying Section 18 of the Limitation Act to the IBC, recoveries will not be thwarted. He also added that the main plank of the submission of the appellant was that a huge sum of rupees 12,000 crore would otherwise go down the drain if acknowledgements in balance sheets were not to be looked at, and stressed the fact that this would be relevant only in recovery proceedings and not in proceedings before the IBC, which are not meant to be recovery proceedings at all, as has been held in several judgments of this court. He then relied upon two High Court judgments from the Andhra Pradesh High Court and Guwahati High Court to strengthen his submission that via Section 18 of the Limitation Act, entries made in balance sheets do not amount to acknowledgement of debt. He also stressed the fact that no date of default has been mentioned in the original form that was submitted with the Section 7 application, and that this would therefore be a non curable defect, on account of which the Section 7 application should have been dismissed at the beginning. He then took us to various judgments of this court, which made it clear that if a period of 3 years had elapsed from the date of declaration of the account of a corporate debtor as a non performing asset, the claim filed by a creditor is a dead claim which cannot be resurrected, having recourse to Section 18 of the Limitation Act. Finally, he argued that the balance sheets in the present case did not amount to acknowledgement of liability, inasmuch as the auditor's report, which must be read along with the balance sheets, would make it clear that there was no undisputed acknowledgement of debt, but that caveats had been entered by way of notes in the auditor's report cannot be relied as a fit evidence for our purpose in this particular case. After hearing counsel for both sides, it is important to first advert to the rationale for the enactment of Section 238A of the IBC, which was enacted by way of the Insolvency and Bankruptcy Code Act 2018. Section 238A of IBC reads: the provisions of the Limitation Act 1963 shall, as far as may be, apply to the proceedings or appeals before the adjudicating authority, the National Company Law Appellate Tribunal, the Debt Recovery Tribunal or the Debt Recovery Appellate Tribunal, as the case may be. In Jignesh Shah versus Union of India, this court referred to the report of the Insolvency Law Committee of March 2018, which led to the introduction of Section 238A as having heard the learned counsel for both sides. It is important to first set out the reason for the introduction of Section 238A into the Code. This is to be found in the report of the Insolvency Law Committee of March 2018 as the question of applicability of the Limitation Act 1963 to the Code has been deliberately upon in several judgments of NCLT and NCLAT. The existing jurisprudence on this subject indicates that if a law is a complete code, then an express or necessary exclusion of the Limitation Act should be respected. In light of the confusion in this regard, the committee deliberated on the issue and unanimously agreed that the intent of the code could not have been to give a new lease of life to debts which are time barred. It is settled law that when a debt is barred by time, the right to a remedy is time barred. This requires being read with the definition of debt and claim in the code. Further, debts in winding up proceedings cannot be time barred, and there appears to be no rationale to exclude the extension of this principle of law to the code. Further, non application of the law on limitation creates the following problems. First, it reopens the right of financial and operational creditors holding time barred debts under the Limitation Act to file for CIRP, the trigger for which is default on a debt above INR 1 lakh. The purpose of the law of limitation is to prevent disturbance or deprivation of what may have been acquired in equity and justice by long enjoyment or what may have been lost by a party's own inaction, negligence, or default. Though the code is not a debt recovery law, the trigger being